Good evening, friends. As we had told on the earlier occasions, Justice Vikas, the passion towards sharing knowledge can be seen on the social media like anything. And we are all eagerly waiting for the book which he's writing. And we are quite sacrosanct that that book will be not only a hit, it will be a mega hit. Or we can say it will be a blockbuster for the legal knowledge as such. And even the common persons can understand that. That's the way he illustrates things. We will ask at the end of the session what type of things can people look upon in that book. Today's session is also quite fascinating for the purposes of the lawyers and common man. That when does the trial start in a summons case? So today's topic, we will not discuss the warrants case. Some brief difference between the summons case and warrant case. We'll ask sir to explain. Though it's not one of the part of the syllabus, if we ask, typically because 4 questions have been given to me, which have to be read out. So we will take one indulgence, the extra 5th question, the difference between a summons case and a warrant case. And as we all know, Justice B. Kumar is not only an erudite speaker, but also a person with immense knowledge. And the way he unblocks the blocks, that is the most fascinating part. And Justice B. Kumar is a former judge of Kerala High Court, and his passion to take legal knowledge started when he was in the Director Judicial Academy. That was to the next level. And thereafter, because of the COVID, we all got connected. I do not know that what positives others have learned, but at least we have been able to persons and resources like Justice V. Kumar, whose knowledge has gone viral in the social media. And we can also understand that Justice Ramkumar's today health is slightly down, but they say that he can be down, but he cannot be out. He will continue to share his knowledge. I'm reminded of Mr. Anil Kumble when he was injured. He came back and played an innings which is remembered for all times to come. Over to you, sir.
Thank you. Thank you, Mr. Vikas. Good evening, friends. You can read the first question.
What do you mean by a summons case, sir?
Summons case, very often we come across the expression summons case, warrant case, etc. What exactly is meant by a summons case? Now, going by Section 2, Clause W, cr.pc, a summons case means a case relating to an offence not being a warrant case. You are not taken anywhere. Summons case is not a warrant case. That is what the cr.pc says, Section 2W. So you have to go and find out what exactly is a warrant case. One has to find out what exactly is a warrant case from Section 2X, Clause X of Section 2 CRPC, which means a warrant case is a case relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So if the offence is punishable with death, imprisonment for life, or imprisonment for a term case. So summons case is a case which is not a warrant case. So summons case can ordinarily be a case where imprisonment is, the extent of imprisonment can be up to 2 years and below. Imprisonment can be awarded up to 2 years and below. Above 2 years means warrant case. This is the conjoined effect of reading Section 2W and X of Section of CRPC. Yes.
Yes. So the next question, which normally will come in the mind of anyone, is when does the trial start in a summons case?
This is a very, very interesting question. Courts have generally taken the view that trial in a summons case starts as soon as the accused, in response to the process issued against him, either appears or is produced before the magistrate, and the substance of accusation is stated to him by the magistrate under Section 251 CRP. The substance of accusation, see, as soon as the accused appears or is brought before the magistrate complies with Section 207 or 208 as the case may be. The prosecution records will have to be given to him, copies of the prosecution records. So as soon as the prosecution records copies are given to him, the magistrate will read the substance of accusation, that is the particulars of the offence, will have to be read over to the accused and explained to him in the vernacular language or in the language known to the accused. This is what is called, then the courts have taken the view that as soon as the accused appears and the substance of accusation is stated to him by the magistrate, trial has started. This is the general view taken. In fact, way back in 1980, Kerala, there's a Kerala decision, Shantamma Radhamani Amma versus Kunju Pillai, 1980 KLT 393. 1980 KLT 393, a decision rendered by Justice S.K. Kadir, who was a very well-versed judge in criminal law. The corresponding citation is 1981 Criminal Law Journal 247. 1981 Criminal Law Journal 247. It was held that as soon as the accused appears and the substance of accusation is read over to him, trial has started. The reading of the substance of accusation or particulars of offence is done by the magistrate in exercise of the power under section 251 cr.pc. Again, in para 16 of Subramaniam Seduraman versus State of Maharashtra, AR 2004 Supreme Court 4711. 3 judges, Santosh Hegde, the author of the judgment. Same view was taken. Again, in SV Enterprises versus Rajashekharan Nair, 2006, 3 KLT 930, a judgment rendered by Justice M. Shashidharan Nambiar. Same view has been taken in that ruling also. But I would hasten to add that the trial in the real sense of the term cannot start merely on the stating of the substance of accusation to the accused under section 251 cr.pc. This is because the accused may voluntarily plead guilty, in which case there is no trial. He may voluntarily plead guilty under section 252 cr.pc. So no trial in that case. So even when the accused pleads guilty, voluntarily pleads guilty, section 252 cr.pc does not mandate that the accused should be convicted on his plea of guilt. The magistrate can still, in his discretion, call upon instead of convicting the accused, call upon the prosecution to prove its case. Therefore, according to me, trial in a summons case can really start when the accused either pleads not guilty or when even after he pleaded guilty, the magistrate in his discretion has not convicted the accused. Thereupon, the magistrate can proceed and take all evidence as may be produced by the prosecution under section 254 cr.pc. So I would respectfully add, of course, nothing wrong in saying that trial starts when the particulars of the offence are read over to the accused, or trial starts when the substance of accusation is read over to the accused. But then, supposing he pleads guilty, voluntarily pleads guilty, there is no trial. So the trial can really start when after reading these particulars of the offence, he pleads not guilty, or even after he pleads guilty, the magistrate in his discretion does not convict him, but calls upon the prosecution to prove its case. In both these situations, then only the trial can start in a summons case. Yes, you may read question number 3.
Yes, sir. Can the magistrate, after the commencement of the trial, instead of completing the trial by either convicting the accused or acquitting him, drop the proceedings against him midway?
Yes, this was a controversial area. In fact, the decision rendered by the Kerala High Court was overruled by a 2-judge bench of the Supreme Court in K.M. Matthew. Of course, I will refer to that. Now, that decision said that in the absence of any prohibition in the CRPC, nothing wrong if the magistrate, after the commencement of trial, drops the proceedings against the accused. Now, this K.M. Matthew citation, I'll give you the K.M. Matthew versus State of Kerala, AR 1992 Supreme Court 2206. AR 1992 Supreme Court 2206. It was the judges were Jagannath Shetty, who was the author of the Shetty Commission, whereby judicial officers in the whole country were given a lot of benefits, a lot of perquisites. Justice Jagannath Shetty and Yogeshwar Dayal. Jagannath Shetty being the author of the judgment. Now, here in fact, it was after reversing the judgment of learned single judge of the Kerala High Court, Justice S. Patmanabhan, that the Supreme Court held that There's, in the absence of any prohibition in the CRPC, nothing wrong in the magistrate dropping the proceedings after the appearance of the accused. That was the view taken. In fact, after this view, what happened was the magistrates all over the country, throughout the length and breadth of the country, used to drop the proceedings or discharge the accused for one reason or the other, following K.M. Matthew. And it took nearly 12 years for the Supreme Court to realize its mistake. And K.M. Matthew was overruled by a 3-judge bench in Adalat Prasad versus Ruplal Jindal. Citation is AR 2004 Supreme Court 4674. AR 2004 Supreme Court 4674, 3 judges. The author of the judgment being Justice Santosh Hegde. The other judges are Justice S.B. Sinha and A.K. Mathur. They, in fact, this was reiterated by another 3-judge bench, Subramaniam Seduraman versus State of Maharashtra. AR 2004 Supreme Court 4711. AR 2004 Supreme Court 4711. Again, judgment rendered by the same judge, Justice Santosh Hegde. Their lordships held that no, K. Matthew cannot be upheld because once the substance of accusation have been read over to the accused, once the process has been issued to the accused and the accused has appeared and the substance of accusation have been read over to the accused, there's no provision in the CRPC to recall the process issued and to allow the accused to come to the pre-process stage and plead for a termination of the proceeding, premature termination of the proceeding. No, it will amount to review. If such a view is taken, it will amount to review of the order issuing process, of the order reading the substance of accusation, etc. And no, there is no power of review in the CRPC for a criminal court, unlike in the case of a civil court. Civil court, there is a power of review, whereas CRPC, there is no power of review for the magistrate. That was the view taken in Adalat Prasad case. So after 12 years of K.M. Matthew, it was overruled by the 3-judge bench, virtually resurrecting the view of Justice S. Padmanabhan of the Kerala High Court. You may read question number 4.
Immediately after his appearance in a summons trial case, the accused filed an application requesting the magistrate to drop the proceedings since the ingredients of the alleged offence were absent in the substance of the accusation proposed to be stated. Even though the magistrate was convinced that the ingredients of the offence were absent, he dismissed the application filed by the accused by relying on the dictum in Adalat Prasad versus Ruplal Jindal, AIR 2004, Supreme Court 4674. Will the accused be able to successfully challenge the order of the magistrate?
See, summons trial case. Warrant was summons was issued to the accused. Accused entered appearance. Then the copies of prosecution records were furnished to him. He is appearing through a counsel. There's a counsel appearing for him. The counsel raised a contention that please terminate the proceedings against my client because the materials furnished to me do not make out any offense at all. The ingredients of the offense are absent, totally absent. In such a case, why should the accused suffer the trauma of a trial? Why should he suffer the ordeal of a trial? So please drop the proceedings. Magistrate said nothing doing. Ruplal Jindal, Adalat Prasad versus Ruplal Jindal prohibits me from dropping the proceedings. That is the view of the magistrate. The question is whether the magistrate was right or wrong. In fact, the magistrate was wrong because what was laid down in Adalat Prasad and what was laid down in Adalat Prasad was that after the commencement of trial, when does the trial commence? With the reading of the substance of accusation. Now, after the commencement of trial, the case should go on and the trial should go on and it can end only in a conviction or an acquittal. Now, the question here is whether trial has started. After the appearance of the accused, the counsel appearing for the accused was sharp enough to notice that the materials sought to be read over to him do not contain the ingredients of the offense. No offense is made out. That is why he made a submission to the magistrate. Please don't read the substance of accusation to the accused. Please drop the proceedings so that the accused need not undergo the ordeal of a trial. This was not acceded to by the magistrate, who thought that he was bound by Adalat Prasad. Now, this is a via media, in fact, a very tightrope walking done by the Kerala High Court in two decisions of the Kerala High Court, one by this humble self. In fact, there's one decision of the Supreme Court, that is SEBI versus Gaurav Vaishnav, 2016, volume 14, SEC 430, where Justice Kehar has, speaking for the bench, has observed that material facts constituting the offence for which an accused is being charged must mandatorily be put to the accused. Material facts constituting the offence should mandatorily be put to the accused. And a lack of material facts which are vital to establish the ingredients of the offence cannot be viewed as a procedural omission. The above requirement is not a procedural omission, but it is a substantive requirement. Therefore, if the material facts are not there in the substance of accusation to be read over to the accused, that is not a proper compliance of section 251 cr.pc. So it was noticing it that the counsel raised that please drop the proceedings. Magistrate was unwilling. But this is a case where the trial is yet to start. This is a case where the substance of accusation is yet to be read over to the accused. Therefore, the bar under Adalat Prasad and Subramaniam Seduraman may not apply here, because the trial has not started. The bar will apply only if the trial has started by the magistrate reading out these particulars of the offence to the accused. Before reading out the particulars of the offence, the counsel very vigilantly raised a point. See, the materials do not make out an offence. So please don't start the trial. The magistrate found that he was of the view that he was bound by Adalat Prasad. Magistrate was wrong. In fact, the Kerala High Court, there are two decisions. One is by Anandavel versus Food Inspector, 2010, volume 3, KLT 449. 2010, volume 3, KLT 49. That's a decision rendered by this humble self, where the High Court held that since the trial is yet to commence, the accused will be within his right to plead for a discharge, or rather, technically it is not a discharge. In a summons case, the accused can say that he may be, the proceedings against him may be dropped, because there is nothing to be read over to him. The ingredients of the offence are not made out, so nothing to be read over to him. So it may be, the only thing is, after the appearance of the accused and before the commencement of trial, this has to be done. So the counsel has to be very vigilant. The other day I referred to the Latin maxim, vigilantibus et non dormantibus juras obviant. The law helps only those who are vigilant and does not help those who sleep over their rights. Here is a case where the counsel was very vigilant, and therefore before the commencement of trial, he raised this point. And the magistrate, if the magistrate had cared to peruse the records, he would have been convinced that in fact, magistrate is convinced there. Magistrate was really convinced that there is nothing made out against the accused, but he wrongly found himself bound by Adalat Prasad and rejected the application. So the accused have to go to the High Court or the sessions judge to ventilate his grievances. In another case, police charge sheeted summons case, also yet another learned judge, Justice Basant of the Kerala High Court, in Dr. Kamala Rajaram versus DYSP, 2006 Criminal Law Journal 1447, corresponding to 2005 3 KLT 617. It was held that the magistrate can either drop the proceedings in exercise of his power under section 251, but since it is a police charge summons case, he can also terminate the proceedings under section 258. If the principal witness has been examined, it will amount to an acquittal. If the principal witness has not been examined, it will be a discharge. technically discharged. Therefore, 258 can be pressed into service by the magistrate. These are the two rulings, according to me, to my knowledge, which I have taken a via media. Before the commencement of trial, if the accused is able to make out a case that there's no offence made out in the particulars of offence, the case can be terminated without the commencement of trial. The accused need not undergo the or. Therefore, my conclusion is that in all cases where there is want of sufficient allegation or incriminating material making out the offence in a summons case, instituted either on a private complaint or on a police report, if the counsel appearing for the accused is vigilant enough or sharp enough to notice the lack of material, he can plead for dropping the proceedings so that the accused need not undergo the trauma of a trial. With that, we conclude today's webinar. Thank you. You are not audible. You are not audible.
I've not unmuted myself. So I am also controlled by the computer only.
Yes.
What is the fundamental difference between a summons and a summary trial in terms of taking evidence?
Summary trial, it is the substance of evidence needs to be recorded. It is very simple procedure in summary trial. In a petty case, the accused can even plead guilty through post. He need not even engage a counsel. So a procedure is summons procedure only. 250 instead of 251, it is 261. The procedure is same, but the long drawn out procedure of trial, etc., need not be complied with in a summary. Proceedings are summary in nature.
We'll ask Justice Ramakrishnan to share his insights.
Is it not necessary for a magistrate, before reading out the particulars of offence, to make out his mind as to whether any ingredients are sufficient for the purpose of reading out alone itself?
How many magistrates do that? It is done as an empty formality.
No, it is not, because
ritualistically done.
Once it is read over, automatically the accused has no option to say whether the charge is there or not. He can only plead or not to plead guilty.
Yes.
Is it not better for the magistrate to find out as to whether
apply his mind? Yes. It is always, it should be. Magistrate should always apply. But no. The docket before them, the docket explosion, the case pendency of cases before them is so prohibitive that they won't find time to apply their mind even.
No, that was, I guess, I think it was one of the decisions of this Kerala High Court, where the Kerala High Court has said, even if you plead guilty, a court can appeal can be filed against it, because normally when pleading is there, it is not there.
No, he cannot file an appeal. He cannot challenge the conviction. He can only challenge the sentence. Under but section, I think it is section 375 or so. 375. Let me see, check. Is it not section 375?
No appeal can be filed except 272. 372 is the appeal provision. I think there it comes.
It will be 375. Interpreting that section, 376, no appeal in petty cases. 375, no appeal to settle. 375, no appeal if the accused pleads guilty, except on the question of sentence. But there, Justice Subramaniam Poti, the Kerala High Court, had taken the view that even if he, in a case where he has pleaded guilty, if there was nothing to plead guilty, he can even question the conviction. Because it was a ritualistic formality undergone by the magistrate as well as by the accused. Without knowing what exactly is the material, he simply pleaded guilty. But actually, there was no incriminating material against him. So the Kerala High Court, interpreting section 375 cr.pc, held that notwithstanding his plea of guilt, he can challenge the conviction also, because there was nothing to be convicted. There was no material to plead guilty.
Because the ingredients of the offence have not been made out.
Not made out.
Even he is admitting the facts, not the commission of offence. It may not amount to commission of the offence.
I think it is 1978 KLT also by Justice Subramaniam Poti. Very shrewd and intelligent judge.
No, really, it's an area where always there will be doubt whether it is a plea of whether the charge will have to be framed, etc., etc. So it's nice to hear Justice Ramkumar always.
Thank you.
Thank you.
So I thought that let us have a flurry of knowledge from SK Prem.
Now, this was a very erudite class. I cannot add anything more. But just for the purpose of learning myself, as of course Justice Ramkumar has put in, the word trial has not been defined in the present cr.pc, maybe rather purposefully. But of late, in a ruling by Justice Sundaresh, Satyendra Kumar Antil versus CBI, that's a 2022 judgment, which is reported in AR 2022 at page 3386. Justice Sundaresh goes on to hold that the word trial, even though it's not explained or defined under the cr.pc, by way of a judicial interpretation, an extended meaning has to be given to the word trial, even for the purpose of enlarging that accused on bail at the stage of investigation. Now, I don't know whether now whatever is said by the Supreme Court, of course, is not the law. And of course, as Justice Ramkumar has put in, the trial of summons case, it is dealt with in Chapter 20, starting from sections 251 and ending at 259. And as we all know that under the summons case, it is not necessary to frame a charge in writing, because stating the substance of the offence to the accused is enough under 251. Now, this is a gray area which has created a confusion. Now, Justice Ramkumar has both cited K.M. Matthew, the two-judge bench, which was overruled in Adalat Prasad, the three-judge bench in 2004, and within a month thereafter, another three-judge bench. Now, the first three-judge bench was Justice Santosh Hegde, Justice S.B. Sinha, and Justice A.K. Mathu. Whereas in the next three-judge bench, the solitary substitution is that of Justice A.K. Mathu with Tarun Chatrath, Justice Tarun Chatrath. Now, Justice Santosh Hegde and Justice Sinha, who were there in the earlier three-judge bench, they were the parties to this three-judge judgment. That is, I'm talking about Subramanian Seduram. Now, Ramkumar, so I just have one doubt, because K.M. Matthew was a case, if we read closely, K.M. Matthew was a case after issuance of summons on a complaint, after entering the appearance, accused he pleaded not guilty. Now, before evidence was recorded, he requested the magistrate to drop the proceedings. The magistrate drops the proceeding. The revision went on to the Kerala High Court. That was allowed, against which the accused petitions to Supreme Court. And the Supreme Court held that if the magistrate is satisfied, then of course the magistrate can drop the proceeding. This was K.M. Matthew. Now, 12 years thereafter comes Adalat Prasad. Now, if we closely read Adalat Prasad, a complaint was filed against the accused, cognizance taken, summons issued, accused then moved the Delhi High Court in the case against the order of issuance of process, which was allowed. Then in the revision, it was remanded for fresh consideration. Now, pursuant thereto, the magistrate recalled the summons, which again was challenged before the High Court on the ground that the magistrate had he had no jurisdiction to recall the summons. The Supreme Court holds that K.M. Matthew is not a good law. And kindly see what the Supreme Court says. Supreme Court says that the remedy in such a case lies only in invoking 482 cr.pc. Now, kindly see, the Supreme Court proceeded on the basis that Adalat Prasad was a summons case. But really, Adalat Prasad was not a summons case. It was a warrant case which was covered under Chapter 19. And please see, the Supreme Court in the judgment has made it clear that it was not necessary to go into the question whether a summoning order amounts to an interim order or not. Then, of course, comes the third judgment, which is Subramanian Seduram. Almost within a month. Summons in the complaint that was challenged by the accused company. The company was an accused. Company challenges before the very same magistrate on the ground that he could not have taken cognizance of the offence because of a defective statutory notice which was issued and seeks for a discharge. Application was rejected. Second application for discharge was filed, and please see, that was allowed. Following K.M. Matthew. taken in revision before the Sessions Court, allowed, or challenged before the Bombay High Court, dismissed, SLP before the Supreme Court, first vote, withdrawn. After 10 days, first application filed by the executive director of the accused company on the very same grounds that was taken in the first application, which was allowed by the magistrate, holding that the statutory notice which was issued prior to filing of the complaint, that was not in accordance with law. Again, relying on KM Matthew, things were done. The revision before the Bombay High Court. That was allowed, reiterating its earlier view. And the Supreme Court was approached. And the Supreme Court reiterates Adalat Prasad, emphatically holding that the sole remedy is to invoke Section 482 CRPC. Now, the Supreme Court said so for the reasoning that it was a challenge to an order in an interlocutory stage. Kindly see, the Supreme Court goes into a finding that this was a challenge made to an order in an interlocutory stage. In my limited knowledge, I would say that this was a wrong proposition. Now, even prior to Adalat Prasad and Subramanian Sivaraman, the Supreme Court in a plethora of precedents considered the maintainability of revision. To cite just one case or one ruling, I would just cite KK Patel versus State of Gujarat, which is AR 2000 Supreme Court 3346. That was KK Patel, which held that in deciding whether an order which is challenged is interlocutory or not, for the purpose of 397, the sole test, it is not whether the order was passed during the interim stage. The feasible test for the Supreme Court held was whether by upholding the objections which would have been raised by a party at that particular point of time, whether that would result in culmination of proceeding. If so, any order which was passed, that would not be interlocutory. Now, the principles were laid down in Amarnath, 1977, Madhurima, 1978. All these principles were followed.
VC Shukla.
VC Shukla, exactly, 80 Supreme Court. Correct, sir. Then, of late, we can see Dhariwal Tobacco, that is the 2009 decision, 2009 2 SEC 370, which held that issuance of summons is not an interlocutory order within the meaning of 397. So, revision is perfectly maintainable, not merely 482 as held in the Adalat Prasad or Subramanian Sivaraman. As I already said, the Supreme Court in Adalat Prasad goes on to say it is not necessary for this court to go into the question whether the order which issued the process that amounts to interim order or not. Adalat Prasad did not even decide that issue. Another decision comes in during 2012, which is Bhushan Kumar case, AR 2012 Supreme Court 1747, two-judge bench decision by Justice Sadachivam and the second judge of Justice Chalameshu, which renders an absolutely divergent view as against both these three judges' books, and says that it is inherent in Section 251 CRPC, that inherent to what extent that when an accused appears before a trial court, pursuant to a summons, see the difference, pursuant to a summons, then the bounden duty of the bounden duty, as Justice Jamkumar has put in Anandavale, as well as in Kamala Rajara 2005. Now, the magistrate, he has to carefully go through the allegations made either in the police report or in the complaint, and then consider what are the materials before him to come to a conclusion whether or not commission of offence is disclosed. And if only the answer is in affirmative, he shall explain the substance of the accusation, whether you are pleading guilty or otherwise. Otherwise, he is bound to terminate the proceeding. But kindly see, Bhushan Kumar uses the word. To this extent, what Bhushan Kumar says is absolutely correct. Because if there is nothing against the accused, no plea can be referred, of course. But Bhushan Kumar says, if it is an affirmative, the magistrate, he shall state the substance of the accusation. Or else, Bhushan Kumar gives him the option to discharge the accused under Section 239 CRPC. Because 239 warrant case trial and that institute upon police report. Maybe the principles is what maybe what the learned judge would have had in his mind. We don't know. So, and so one more thing I would say. Now, what K. Matthew said was, and what Adalat Prasad and Subramanian Sivaraman disagreed was, maybe these would amount to a review under 362. But sir, isn't there a power to recall? Because suppose a court has done a wrong, it is the accusations. Actually, the accusations were wrong or inherently improbable, but nothing could be spelled out. It was a wrong on the part of the court. Then, applying the maxim, actus curiae gravity. Then normally, wouldn't the court have a power to recall the judgment? Because I had laid my hands upon a decision of the Supreme Court in 1995 or 1999. Indian Bank was a Supreme Court. Where the Supreme Court, after referring exhaustively to certain English judgments, like Lazarus Estates case, Supreme Court goes on to say whether it's a civil court or a criminal court, most courts do have the inherent power to recall the judgment. Of course, that was a case of fraud. That was a case of fraud. Still, sir, applying this particular principle, actus curiae eminent gravity, the court has done it wrong. It's not that particular court got that particular power, at least to the extent of doing the undoing the wrong. It should be there. That is my humble submission.
Inherent power should be given. Unlike, see, as in the case of a municipal, as in the case of a civil code, section 151 CPC, such a provision should, why reserve it to the High Court alone?
Sure.
Why can't the municipal, why can't the magistrate rectify rectify a wrong step taken or rectify a mistake committed by him? Like as in the case of a civil code, inherent power should not be confined to the High Court alone. And many of the 482 petitions can be avoided. Because justice can be done at the level of the magistrate himself. But unfortunately, that is not the... And the observation that 482 is the only remedy is also not correct. 397 is also...
397 lies. 397 would lie.
Right with 401 will lie.
But see, unfortunately, 3 judges bench of Supreme Court, not once, but twice. Divergent view by a 2-judge bench. This is what is happening. And we have Article 141 in our constitution which says whatever the Supreme Court says is not the land. Utter confusion, sir. Anyway, sir, that was an absolutely eloquent class. Thank you so much.
Thank you. Thank you.
Thank you, everyone. We are indebted to Justice Kumar, Justice Ramakrishnan for sharing the knowledge. Thank you. Everyone stay safe. And also be tuned with us on our WhatsApp group and social media for the further updates of webinars like speakers of immense knowledge like Justice Kumar and Justice Ramakrishnan. Thank you. Once again, thank you.